Hi, everybody. This is David O'Day with O'Day Schneider PLLC, and today we're talking about free speech rights and being a service member in the case of United States versus Wilcox, a case that asks how far do free speech rights go for service members, especially online. Now, Private First Class Wilcox was a paratrooper who created an AOL profile identifying himself as a soldier, and he posted racist, white supremacist, and even anti-government views. He shared links to extremist websites and chatted with an undercover Army investigator, repeating racist statements and suggesting that the agent attend a rally. Wilcox never called for violence, never encouraged anyone to disobey orders, and he never tried to recruit fellow soldiers into this extremist organization. But his command believed his online activity discredited the Army and threatened good order and discipline, and he was charged under Article 134 of the Uniform Code of Military Justice. Now, the case raised a core issue. Can the military punish a service member's speech, no matter how offensive, if the alleged harm to the discipline is only hypothetical? And the Court of Appeals for the Armed Forces wrestled with this question. While military members don't enjoy the full range of civilian rights, the court made it clear they still retain real constitutional protections. And political speech, even when deeply unpopular, sits at the heart of the First Amendment. Unless it directly undermines mission effectiveness, it remains protected. Now, the court approached this case in two steps. First, it recognized that Wilcox's online comments were political speech. As offensive as they deserved the strongest constitutional protection. Second, the judges looked at the evidence. The government couldn't prove that other soldiers saw Wilcox's post, that civilians linked his views to the Army, or that morale suffered. The case was built on speculation about what might happen, and the Court of Appeals for the Armed Forces rejected that, ruling Article 134 requires a reasonably direct and palpable impact, not just a guess about potential harm. Without proof of real-world consequences, the conviction couldn't stand. Now, the decision is important. It established that speculative harm alone can't justify punishing speech in the military. There must be a clear, tangible connection between what a service member says and actual damage to discipline or reputation or mission accomplishment. Incitement to violence, threats, or contemptuous remark towards officials can still be punished along with obscenity, but unpopular opinions by themselves usually cannot unless they cause concrete harm. Wilcox even resonates today in the age of social media, where service members routinely post online, and the case ensures constitutional rights are preserved while reminding us the military retains authority to discipline conduct that genuinely disrupts readiness, mission accomplishment, or crosses other well-recognized legal boundaries. It's important to remember that while speech may be legally protected from criminal charges, commanders still hold wide discretion over careers. They can reassign service members, remove them from leadership positions, or pursue administrative separation. And legal protections of free speech do not always shield someone from professional consequences within the chain of command. Ultimately, United States versus Wilcox underscores that the military cannot criminalize mere belief or offensive opinions without clear evidence of harm. It reaffirms that service members, even in uniform, remain protected by the First Amendment when engaged in core political speech. Thanks for watching the video.